Greetings and welcome to Adverse Possession, Tenant, Title, and Intent, American Jurisprudence. Today we're going to be starting with generally here, but before I get there, I want to mention that we'll also be using Black's Law Dictionary 9th edition to help us with any words that we don't know so that we leave no word behind. And if anyone's out there, let me know how the audio sounds. And we'll get started here. Just waiting to see if anyone here is in the room. And looks like that looks good there. We got the volume looking good here. Check. And looks like we're all Just a second here, make sure all is well and all looks well. All right, great. Thanks, Robert. Appreciate it. And let's get started here. Adverse possession, tenant, title, and intent. So, let's get started here. Make sure we're centered on the screen well. There, okay. What one may do personally in the matter of taking and holding possession of real estate for adverse possession purposes may be done by or through another. Thus, the requirement of actual possession of property necessary to acquire title by adverse possession need not be met by acts of the adverse claimant, but may be met through the acts of another who actually possesses and occupies the land for and in subordination to the adverse claimant. Accordingly, the requirement of actual possession may be met or kept fresh through possession on behalf of the adverse claimant by an agent, licensee, relative, or tenant. The fact that a permittee of an adverse claimant in possession of real estate pays no rent to the latter does not, as a matter of law, destroy the efficacy of such possession for the benefit of the claimant. So, the fact that a permittee of an adverse claimant, one who's permitting it, right, in possession of real estate, pays no rent to the latter, does not, as a matter of law, destroy the efficacy. Okay, so that's case 8, or footnote 8. That's Jackson versus Gallegos, and that's 1934 in New Mexico. Interesting case there. Looks like 1934. So that's why it's a little hard to read. But again, that's something that would apply if you're in that kind of situation there. Let's move along here. Tenant. So section 21, what's a tenant? The requirement of actual possession for purposes of adverse possession may be kept fresh through possession on behalf of the adverse claimant by a tenant of the claimant. In other words, the possession by a tenant of the claimant is in law the possession of the claimant, who may claim the benefits. The claimant, however, is bound by the nature of his or her lessee's possession. So the nature of the agent's possession is going to be the boundaries for the claimant to use that agent or lessees. It has been held that the rule that adverse possession of a third person's land by a tenant injures to the benefit of the landlord generally does not apply if the land is not, either expressly or implied, within the terms of the lease. Thus, a landlord cannot base a claim of title by adverse possession to another's land on the possession of a tenant if the land was not included in the lease. It also has been held, however, that a tenant's adverse possession of a third person's land, not within the description in the lease, may injure the landlord's benefit if the circumstances in connection with such possession justify the implication that it was included by virtue of the lease. So there you go. With the lease, it gets a little bit more complicated. 1924, 1932, 1916. Then we have the Wyoming one here, 1989. 81, Nebraska. All right, we got Dogma Free in the house now too. Great. Glad everyone's arriving here. And all right, we got James Allen Cooper here too. Get up, try and get this message out there. Come on. Get up there. Yeah, we have to do this first, maybe. Oh, there it goes. There we go. As a member of the state, may be a citizen occupying the status entitled citizenship, or he may be a resident alien occupying the status designated resident. Let that sink in. Yeah, and I guess whichever one's going to work the best in your situation here. Again, we're talking about laying claims for adverse possession, so I believe that's it's definitely a good point to have. We've seen that language in here. I've seen, let's see, not sure, but we're going to get into it a little bit here as we dig deeper, because yesterday we went over the basic definitions and the whole idea of adverse possession, and now we're getting over some more of the finer details. So Section 22, generally, to establish title by adverse possession, actual possession of a tract of land claimed adversely under color of title is generally just as necessary as actual possession without color of title. So what does this mean? Let's see. To establish title by adverse possession, actual possession of a tract claimed adversely under color of title is generally just as necessary as actual possession without color of title. So remember, we were talking about color of title yesterday, and color of title is something as simple as a letter to the, I think, the county court or something of that nature, to the clerk saying that you're on that land, and that you just basically make the title stating your name, the description of the land accurately enough to establish a particular date that you initiated your claim, so that the statute of limitations could start ticking at that moment. And also any retroactive laws would not, there would be no retroactivity of laws in the future applying depending on the circumstance once you've established that date. And that can all be done simply by color of title, it seems. But before I even mention anything further, I got to mention that I have absolutely no knowledge of legal lawful matters whatsoever, no education, no training whatsoever, and I do not expect any of this to be construed as advice or recommendations in any way, shape, or form. This is strictly for educational, entertainment purposes as we study American jurisprudence and the roots of our American system of the courts with common law basis. So with that being said, don't try this at home, and let's proceed. So color of title, again, is just a way of establishing a document that states the important elements of establishing adverse possession: the date, the person doing it, and the property that's being claimed. So let's continue here. All right, we got Deborah here just on time. Always there. Right in the just as we get going, so it's okay. It's always a slow start. And we got absolutely dogma free. So let's move along here. So thus, an adverse possessor under color of title must show actual possession of the property in question. If the adverse possession is under color of title, however, it is ordinarily sufficient if only part of the premises described in the color of title are actually occupied, since color of title serves to extend actual possession to constructive possession. Wow. And section 111, which we could check that out real quick. We're on page 50. Let's look at section 111, what they mean there. All right, here we go, 111. And this is generally about, let's see, relating to color or title. Okay, so adverse possession may be established provided that other elements of adverse possession are met if the possession of the property was under color of title, such being an alternative to possession under claim of right. Color of title, however, in the absence of a statutory requirement, is not a necessary element of adverse possession. It is therefore ordinarily not necessary in an adverse possession claim that a claimant have color of title to land actually possessed. In certain jurisdictions, however, statutes may require that a claimant prove color of title to establish adverse possession. Again, the way they're doing this in some of these jurisdictions, they require it because they want some documentation, I think, of the time the start date begins for the statute of limitations, which sets a period for your adverse possession to ripen. Or in other words, an entry under color of title or the subsequent acquisition of color of title before the possession of the land can be deemed to be adverse to the holder of the legal title. So, cool stuff there. Color of title for purposes of adverse possession, where present, serves to extend actual possession. See this? Extend actual possession to constructive possession. So, what the heck is this constructive possession they're talking about here? Because I'm not too sure, but we're about to find out with our friend Black's Law Dictionary here. And that's, was it constructive? I got doing too many things here. Possession. See if I could find it directly. As we know, this is a scanned document I'm searching here. And it's really clunky as far as finding words. Damn. Says, yeah, okay, there we go. All right, so it doesn't have constructive possession under constructive, but it may have it under possession. So we're going to look under possession really quick and see if they have it under there. Wait, what is it called? Constructive. Hang on, I'm looking at some stuff here. You got to give me a moment here while I look through this other document here to scan it, because it scans a lot quicker than the one we're looking at. Come on. Constructive. Let me see if I can just find it. It might not have come up in my search, and if I can just find it direct, it might work. If not, I'm going right to possession. Wow. All right, here we go. Oh, no. Doesn't look like they have. Wait. Just a moment here, guys. I appreciate it. If while we're right here, if you could hit the like, would be great. Subscribe. Yeah, switch the screen here real quick too for everyone, so we see where we're looking into Black's Law right now, and we're searching constructive. And it's a terrible document to search. I'm going to have to come up with something better, but in the meantime, it's something we have. Personally, I like the paper version with a hardcover book. All right, so here we are. Let's see, constructed. No. Wait, oh, gosh. There's so many subheadings of every word. That's consideration, so construct. Damn. And I don't have headings on all the pages either, so it makes it even harder. I think we got here constitution, construction. So we're looking for constructive. Come on, no. We don't have it there. Okay, so we're back to progress. Everyone's still there with me? Possession, constructive possession. All right, so I have to look through possession. No big deal. Let's get right to it. Where'd it go? Come on. Ah, shoot. All right. We're almost there. Jeez. Possession's used throughout this dictionary a lot. And the number of, numbers don't help much either. Possession, evidence, possession, precarious. Wait. Precarious. No, that's the type of possession, is it? No. Wow. All right, this is close enough here. 1311. You guys waited long enough. Thanks for hanging in there for this nonsense. Okay, so we get all kinds of possessions here. Constructive possession, there it is. Damn it. It's because in italics it didn't show up in my search. Okay. 18th century. Control or dominion over a property without actual possession or custody of it. Also termed effective possession. Civil law. Possession by operation of law of an entirety by virtue of corporeal possession of a part. Nice. Yeah, thanks a lot there, Deborah. It's always worth the wait. I made this wait too long, though, so I apologize for that. Say, when a possessor holds title to a property and physically possesses part of it, the law will deem the possessor to hold constructive possession of the rest of the property described in the title. Does that make sense now? So it's the control or dominion over a property without actual possession or custody of it, and it means possession by operation of law, your title, of an entirety by virtue of corporal, meaning you're staying on a possession of a part. When a possessor holds title to a property and physically possesses part of it, the law will deem the possessor to hold constructive possession, right, in law, of the rest of the property described in the title in law. Beautiful. So now we have corporeal possession is possession of a material object such as a farm or a coin, also termed natural possession. Beautiful stuff. Corporeal. Well, body, corporeal, we could look at this too, and just to get it, yeah, we can get that one too. That should be easier to find. It might be around here. Right, 423. So, corporeal. Having a physical, material existence, tangible, land, and fixtures are corporeal property. Great, incorporeal, nice. So, corporeal possession, see possession. We go back to possession. Jeez, what was that? Was that 1411? So having, so that's having a physical material existence. Corporeal is tangible. Interesting though, huh? There we go. We're looking for possession now. That was, jeez. So we can find it from here. Corporeal possession was over here too, and we somehow missed that one. We had constructive possession. We missed right by corporeal possession. All right, so here we go. Almost there. Corporeal possession. Possession of material objects. Oh, we did see this one. Okay, so constructive and corporeal. So now we see it's possession of a material object. So corporeal is referring to the object, not who's, okay. Natural possession. So possession by operation of law by virtue of corporeal possession of a part. So tangible possession of a part. You're living on a part, and the rest is claimed in paper, in law, on the title. So I think that's the meaning there. So there we go. Now we have a good deep meaning of that, I believe, and an understanding, so we can proceed. Color of title for purposes of adverse possession, where present, serves to extend actual possession to constructive possession. Color of title, therefore, may be used to show possession of an entire tract of property, even though the claimant adversely possesses only a small portion of the entire tract. So, possession's 9/10, yes, but constructive possession could be even more. Whatever the title is, I don't know how that works, but depending on the type of land, whether it's lumberland or wilderness or, urban land, it would depend on how much you'd have to possess to claim the rest that's on the title. To actually to possess physically, right? Corporally, and that would allow your constructive possession. Interesting stuff here that that one thing leads to the other here. That we get control or dominion over property with possession or custody of it without. And in the actual civil law is by the part. So from the 18th century, it's changed a little bit, but civil law now has changed. So it's interesting to see the progression of these words over the centuries. Now, it takes a long time to change. And through civil law, it's actually changed, and not by much, just the finer points of it, because it's meaning a part, the corporeal possession of a part. So, very detailed understanding, and it helps you articulate and express your claims in a written manner that make them very clear to any counterclaims against you, which makes it a tight title. So let's continue here. Color of title. Shh, you're not supposed to say that. Color of title, therefore, may be used to show possession of an entire tract of property, even though the claimant adversely possesses only a small portion of the entire tract. So, observation, the requirements for acquiring title by adverse possession may be less stringent if the claimant enters under color of title than if the claimant does not. So, adverse possession, however, cannot necessarily be proved by less evidence when the entry is under color of title than when it is not. It's just the requirements may be less stringent, but it's not going to prove with less evidence. So, as an observation, find distinction for good practice. Let's continue. And that was actually a digression there. And then we can see the sections we've already gone over as possession under claim of right, see generally, and what constitutes color of title, 118. Do we All right, let's look at that one. And then we're going to go back. You Have Rights, Cops Have Duties was on here last night, and he gave us some examples of this. So let's get right to this part of it and read it from American Jurisprudence and see what they say. So generally, Section 118, the color of title. Color of title, for purposes of adverse possession, is that which gives the semblance or appearance of title, but which is not title in fact. It is an instrument, record, or writing which, on its face, professes or appears to pass title, but fails to do so, such as due to the lack of title in the person from whom it comes, or the defective mode of conveyance used. Conveyance was the voluntary transfer of the property. Color of title need not be an imperfect title of a sort that could, without aider, ripen into absolute title, but need only show some evidence of the claimed ownership by the grantee. It is any semblance of title by which the extent of a person's possession can be ascertained. It is any semblance of a title. Okay, even if it's an imperfect title, meaning to ripen into an absolute title, right? So it need not be that, right? But need only show some evidence of ownership by the grantee, the person, right? So it is any semblance of a title. So it's really just to establish evidence that you have possession, and it can be ascertained. Color of title as a basis for adverse possession depends entirely on the intent again, and meaning of the instrument purporting to convey a title. A writing that does not on its face profess to pass title, but which expressly states that the title will be conveyed at a future time and on certain conditions, is not sufficient to constitute color of title. Color of title can only arise out of a conveyance purporting to convey title to real property, but which, because of some defect, fails to do so. If an instrument actually passes the title to property, it is not color of title. Oh, so you had a good adverse. Nice. Oh, good to hear that, Deborah. Yep, and as long as you have the right evidence and the intent on your side, then that's how it should go. Well, I'm glad to hear that you went on that. Now, if I can only clear the comment. Go away. There we go. Okay. So, observation, possession of real property taken under authority of a statute is under color of title, even if the statute is unconstitutional. Wow. Even if the statute is unconstitutional. Wow, that's footnote 10. We got to look at that one. 1930, are you kidding? White versus Spark Hill Realty Corporation. 1930. Louisiana? No, what is that? Connecticut. Wow. Then we have defective instruments. Okay, but we're not going to get lost in the weeds. We need to get back to the lesson here, which was... We're here on page 50. Tax deed or title. Ugh. Okay. A tax deed or title, even though invalid, generally constitutes color of title, on which adverse possession under color of title may be based. However, for a person to acquire title to land through adverse possession, even when relying on an invalid tax deed or title of color as title, that person must have made an actual entry on the land and taken actual possession of at least part of it. So there we go. Possession under an invalid tax deed need not be by the grantee personally to ripen into title by adverse possession, but may be through an agent, licensee, or relative acting for the grantee. So that's interesting here. Almost in the form of a trust, you'd say, huh? In that form, but not. Because I don't think you can have any conditions within it. Then it would not necessarily be the agent wouldn't represent the claimant. Interesting stuff here. Let's move along here. Constructive possession. Here we go. Cool. The constructive possession of real property is presumed to be in the holder of the record title until there is an ouster and expulsion of the record owner by actual adverse possession or actual hostile possession by another under a claim of title. A true owner who is in actual possession of a part of the land claiming title to the whole has the constructive possession of all of the land, but that is not in the actual possession of an intruder. Under the rule that the constructive possession of property is in the holder of the record title, a grantee of property is in constructive possession, although the grantor remains in actual possession in the absence of evidence of any hostile claim by the grantor against the grantee. Constructive adverse possession of land ordinarily only occurs if actual possession of at least part of a tract has been taken under color of law of title. In the absence of adverse occupancy under color of title, there can be no constructive adverse possession of property on the part of an adverse claimant under a claim of right. The law requires actual possession of all of the property claimed. Wow. So in the absence of the adverse occupancy under color of title, there can be no constructive adverse possession of the property. So you have to be on the whole property if there's no color of title. Interesting observation there. And then we have our footnotes. Let's see here. Adverse possession action. Constructive possession can never be ousted by anything less than actual possession maintained for the necessary period of time. Time and title. There it is. Look at that. Okay, now we can keep moving on here. Generally, we're on to ownership. Acts of ownership. Acts of ownership by the adverse claimant that are of such nature as a claimant would exercise over his or her own property and would not exercise over that of another, and amount to such dominion over the property as to which it is reasonably adapted, ordinarily constitute acts of actual possession. So dominion, and of course that would mean defending it too. Specifically, actual possession for the purposes of an adverse possession claim may be indicated by the claimant's receipt of the rents, issues, and profits of the property, conveyance of the property, grant of permission to others to use the property, leasing of the property, encumbrance of the property, quarrying of the property, building on the property, improvement of the property, or maintenance of the property. So these are all indications, right, of actual possession for the purposes of the claim of adverse possession. On the other hand, the uses of property for hunting, fishing, camping, and other recreational purposes ordinarily are not sufficient acts of dominion to constitute actual possession for adverse possession purposes. Likewise, the surveying and marking of a boundary is not an act sufficient to constitute possession. I didn't say anything about farming on it, though, does it? Maintenance is a great one. Okay, thank you there. You see, this is a good tip here. Maintenance. And then we have James Allen Cooper. Requirements for obtaining land by adverse possession equals a trespasser is entitled to legal ownership of property if his occupation of property is hostile for a period of years by state statute. Yeah, that's one way of it happening. Another way is what one of our audience said yesterday, that sometimes there's people that have property, large amounts maybe, and they've gotten old. They've either passed away or they're too old to maintain it, and there's no one else for them to pass it on to. So therefore, they would, they'll just allow the property to, you just go there, whatever, and the title will slip to the person occupying it. So as long as you can defend it, there's not going to be any claim against you from the legal claimant. And when the legal claimant passes on, there's no one else have legal claim to that, and you're the occupier of the property, and you're the one maintaining the property. So over a period of years, you become the title in absolute fee simple. So the owner of the title. So there it is. At least that's one instance that I've heard. I can't say any of this from my own personal experience. I'm learning about this stuff as we're going along here. So let's continue. We finished the end of this? Yes. Combination of acts. Ooh, grazing of livestock. Look at this. All acts of a possessory nature by an adverse claimant are considered collectively rather than independently in determining the sufficiency of actual possession for purposes of an adverse possession claim. Adverse possession, thus, may be evidenced by a combination of various acts, such as using the land for grazing and the removal of timber, grazing and gathering a natural crop, grazing and cultivation, grazing, cultivation, and removal of timber, grazing, gathering a natural crop and cultivation, grazing, gathering a natural crop and removal of timber, gathering a natural crop and cultivation, gathering a natural crop, cultivation and removal of timber, or cultivation and removal of timber. Oof. Mouthful. So those are all separate cases why they do this, because they all have separate footnotes. Nice thing about American jurisprudence is that they are thorough about this stuff. So whatever your application is, you're not getting a cookbook approach, you're getting a common law approach that you're going to try to apply for the fullest extent that it's benefiting you, but you're going to be encumbered by statutes and other things along the way. Therefore, those are always taken into consideration and brought your attention to within this process so that you have a sound practice. Let's continue here. And we got everything here. Okay, good. All right, we're on to residence. Maintaining a residence on property is an act of actual possession for purposes of establishing a claim of adverse possession. Generally, however, actually residing on the property claimed is not necessary to constitute actual possession and to establish title by adverse possession, because a person may be in possession of real estate without residing on it. Statutory provisions, however, may have an effect on whether residence on the property is required. There you go. Perfect example here. Statutory provisions, depending where the location is and they have jurisdiction, you have to look at those statutory provisions. They don't look good. But look, 1907, 1960, here's 2006 in Washington, 56, 2009, a lot of 2009 stuff, Kansas, Connecticut, All right. So here we go. We're on to cultivation now. Cultivation of land is a sufficient act to constitute actual possession of the land for purposes of adverse possession. There we go. Cultivation of land may take the form of growing crops, or farming, or setting out an orchard and caring for the trees. Look at this, setting out an orchard and caring for the trees. There's an authority that holds that regular mowing of a property constitutes cultivation for purposes of adverse possession, although another authority holds that mowing is not a sufficient act to constitute possession. Sporadic cultivation does not constitute adverse possession. So here we go. 5 says it says mowing is okay. 6 says mowing's not. So let's see here. Sufficient. 5 sufficient is South Dakota, and I ain't gonna cut it's Ohio, Georgia. Of course. Let's get away that easy. All right. That's pretty funny. Good stuff here, though, I'll tell you that. Texas. Waco. Okay. All right, so we're on to cultivation necessity. Although the cultivation of land is an evidence of actual possession, cultivation generally is not necessary to establish actual possession for purposes of adverse possession. Oops, mowing was sufficient for your case. Good. I'll get up there. There we go. Mowing was sufficient for your case. So there it is. That's your maintenance. I guess in some other case, it was probably the type of mowing they did. They probably didn't do real mowing. They just claimed, you know what I mean? Who knows? Or they did it not frequently enough. They did it once. Who knows? We have to look at the case text to really see that. And that's why that reference is there. Of course, it goes beyond the patience of tonight's panel. So let's continue. Some statutory provisions, however, may require the cultivation of real property as one of a limited number of acts to establish title by adverse possession. So let's look at our practice tip. I love these. Practice tip. Under a statute recognizing adverse possession of land, if it has been protected by a substantial enclosure, or if it has been unusually cultivated or improved, the adverse claimant need only prove possession by one of the means stated. Wow. That's pretty cool. So you pick one of them and pick the best, I would say. Cultivation looks pretty good. Pasture or grazing, section 30. Using land for pasturing or grazing of animals may be sufficient to constitute the possession necessary for adverse possession. Some authorities hold that if grazing or pasturing is relied on as evidence of actual use of land to support a claim of adverse possession, it must be accompanied by the enclosure or designed enclosure of the land. Such authorities hold that one does not have adverse possession of unenclosed land by using it for grazing or pasturing. So you must have a fence or something to enclose it. Other authorities, however, do not require that the grazing or pasturing be accompanied by the enclosure of the land, and holds that a claimant may be in adverse possession of an unenclosed land by using it for grazing or pasturing. The adverse possession of lands by grazing is limited to those areas that are reasonably suited for grazing purposes. Practice tip. If the claimant has enclosed the land with a fence, it is not necessary to show that any animal actually grazed up to the fence line if the claimants and their predecessors claimed that all the land within the fence and treated it as their property to use if they wished. So, interesting thing there, too. Pasturing of animals with a substantial enclosure is sufficient to establish the elements of adverse possession. Good stuff here. Removing timber or timber-based crops. It has been held that cutting timber may be sufficient to establish a dominion over property necessary to a claim of adverse possession, but it has also been held that the cutting of timber or trees is not sufficient evidence of actual possession. If the land in question is woodland, there must ordinarily be such continuous and persistent cutting of timber wood from the tract as to evidence a claim of ownership and be an advertisement to the world that the party is occupying the entire tract. Otherwise, occasional or sporadic entries on the land for purpose of cutting timber are not sufficient to constitute actual possession to establish title by adverse possession. Tree farming, when carried out as a manner to attract the attention of those entitled to notice, can be evidence of actual possession for purposes of possession. Tree farming, I love it. Making turpentine, using maple groves, or gathering nuts or similar wild crops may also amount to actual possession of timberlands if the acts amount to more than a trespass. Gathering nuts, making turpentine. Oh my Lord. See, adverse possession could not be acquired of land adjoining the land actually possessed under a conveyance amounting merely to color of title if to the two adjoining tracts merely by cutting timber on it and warning trespassers off a few times. Missouri, Georgia. Even if an adverse claimant could establish that her husband had cleared and sold cedar trees from the tract, that was not sufficient to establish actual and visible appropriation of the land as required for adverse possession. And that's in Texas, 1990. Yeah, interesting stuff. And we're in fencing here, I think. Fencing, yep. The enclosure of land, either of itself or in connection with other acts of dominion, may constitute the possession necessary for adverse possession. A fence is an outstanding symbol of possession, and the fencing in of property is very decisive in determining the possession for purposes of proving adverse possession. See, fencing in an area of land is an act of ownership and the actual possession of property necessary for a claim of adverse possession can be established by designingly enclosed fence, or a fence that defines the limits of the claim and warns the true owner of the necessity for him or her to take protective measures. Protective measures, so you got to defend it. The mere existence of a fence around the property for a period of at least 55 years offered a substantial basis for the holding that the defendant property owners held title to the property within the fence by adverse possession. Beautiful. All right, necessity. So, although the enclosure of land is evidence of possession, the enclosure of property is not necessary to demonstrate possession for purposes of an adverse possession claim. It is therefore not essential to the acquisition of title to land by adverse possession that it be enclosed or fenced. Some statutory provisions, however, may require enclosure as one of a limited number of acts ordinarily written in the disjunctive to establish title by adverse possession. Furthermore, in cases involving a claim of adverse possession to wild or woodlands, some authorities may require enclosure as one of a limited number of acts to establish title by adverse possession. So Deborah says, yes, I had a neighbor that wanted to put his fence on 1 foot of my property, and I said no. Yeah, sneaky. That's right. You tell him no, because he's going to encroach and he's going to get his, easements, things like that. They even fall in a different category, but good work on that. Who knows? Constructive possession, right? Let's see, we've been on here almost an hour, and we're getting to adequacy of enclosure. And as to your fences here and stuff. So if an enclosure of property is relied on as the act of possession in an adverse possession claim, the enclosure should be appropriate for the purposes to which the premises are adapted or for which the occupant may desire to use them. An enclosure for purposes of a possessory action for land determined by an enclosure is not limited to fence and walls. So I guess you can use stones too to mark out your land, huh? The enclosure, like other acts of possession, must be sufficient to fly the flag over the land and put the true owner on notice that the property is held under an adverse claim of ownership. A fence, even if it is insufficient to turn livestock, may be sufficient to fly the flag and put the owner on notice of adverse possession. In fact, an enclosure having no purpose of physical exclusion may be sufficient to indicate the boundaries of an adverse claim, even though it is only a mere furrow turned with a plow around the land or a line marked by cutting away the brush. Full or complete enclosure of the land is not required. Let's see. Although, here's our observation. Although enclosing land within a fence is sufficient to raise the flag of adverse possession, a fence kept simply for convenience has no effect upon the true boundary between tracts of land, because, unlike a boundary fence, a fence of convenience gives rise to permissive use, and permissive use will not support a claim for adverse possession. So that's interesting there, too. I love this raise the flag of adverse possession. A fence kept simply for convenience has no effect on the true boundary, unlike a boundary fence, right? There's no rise of permissive uses, and permissive use will not support a claim. So there it is. Really cool stuff here that we're coming across. I've certainly been coming a lot. Evidence that a fence has been considered the boundary by both parties, and that the adverse possessor had openly used the land for pasture and a garden was sufficient to satisfy the element of possession to claim the property between the surveyed boundary and the fence. Beautiful. A fence's existence can support, let's see, that was in Missouri. A fence's existence can support an adverse possession claim, even if the fence does not completely separate disputed property from the land. Instead, what matters is whether the partial fencing serves to visibly delineate the claimed area by indicating how it is set off from other property. So good case there to read up on. And then adequacy of enclosure. Let's see. We're getting pretty thin on the audience here. I think we've gone over a lot today. I'm going to take off on this part so we can continue here on the next one too, because this is getting really, really dense as far as the knowledge goes. Been learning a lot. I hope you guys have been too. We're on to section 35. That's page 75. Section 35, and that's going to be enclosures. Adequacy. Cool. We got some good words we've learned. So as the journey goes on, I believe we're picking up a lot of operational knowledge here now that's going to help us in all kinds of things in understanding adverse possession, tenants, the title, and the intent of the land, and why it should be in the possession of the people that are on it, whether a portion of it or the land as a whole, and how that constructive title can become the absolute title based on the color of title, which is not even a defective title, but just evidence of the person on the land, and the time, so that you can establish the elements required for an adverse possession claim. So, on that note, yes. Oh, water in your native tongue. Great. You're welcome. I want to thank you all for coming tonight and joining me on this journey of American jurisprudence, because this is where the rubber meets the road for the people. This is really the power of the people here, is the common law of our courts. It's not the courts, but the common law exercise of our courts. And it's only up to the people to insist on this. You're not going to find the bar insisting on an American jurisprudence approach to every case, I'll find. At least that's my opinion. And you may find the same. That's why it's up to us to learn this and to be able to apply it so that the people can benefit from this style of jurisprudence that's uniquely American. And actually, it's been probably the most progressive use of culture in expanding personal liberties and protecting private property. On that note, I would like to thank you all again for coming, and please subscribe, hit the bell notification so you make sure you're notified whenever we do go online, and we'll be online with a new one soon, and I guess we'll be continuing on adverse possession because there's still more to learn. Again, thank you all for coming. I salute you all, and I'll see you all in the next one. Peace out.